He told me there was no recording. Those were his words, stated under oath, looking directly at me. No body camera, no vehicle camera, no footage of any kind. He said it the way he had said everything else that morning, without hesitation, without qualification, with the full weight of a uniform and 20 years behind it. I want to ask you something before I tell you what happened next. When someone in a position of authority tells you something that you later discover was not true, what do you believe about how that happened? That they miscalculated? That they forgot? Or that they looked at the room and made a decision about what the room would accept? I am Catherine Merrill. I spent 9 years at the defense table in this courthouse, 9 years at the prosecution table, and I have been on this bench for 9 more. I have been waiting a long time to say certain things clearly enough that they belong to the record permanently. This channel is where I say them. If you believe that what happens in courtrooms deserves witnesses, real ones, not spectators, subscribe and hit the bell. Every subscriber is one more person choosing accuracy over spectacle. And when this episode ends, I want you to write one thing in the comments. One thing from what you hear today that you are going to stop pretending is acceptable. Just one. I will read every one. Because what the record needed that morning, and what I am about to show you, is a witness who stayed. He told me under oath that there was no recording. He said it clearly, he said it without hesitation, and he said it looking directly at me. And then the recording loaded on the screen behind him. I want to tell you about that moment. Not just what happened when the footage appeared, but everything that led to it. Because what happened in that courtroom on that Tuesday morning was not a surprise to me, not entirely. And the reason it was not a surprise tells you something important about how this room works, and about the particular kind of certainty that brought one officer to a place he had not anticipated. Let me start with the room before he entered it. I had reviewed the file the night before, the way I review every file, myself in full, without the summary my clerks prepare, because the summary skips the page that matters. I do this because I spent 9 years as a public defender in this building, and I learned in those 9 years that the page that changes everything is almost never the page anyone thinks to mention. This file had a page like that. I had read it twice. I set it aside and went to bed and thought about it the way you think about something when you know the proceeding tomorrow is going to require you to be very still. The officer arrived that morning with the particular posture of someone who has testified before and been believed. I have watched that posture from the bench for 9 years, and I knew it from the other side for 9 before that. From the defense table, where a client's fate sometimes rested entirely on whether the room would believe the officer over the defendant. The posture is recognizable. It is the posture of someone who understands that their credential enters the room ahead of them, and that the room generally accepts it. He was in a pressed uniform. He moved through the gallery with the ease of someone accustomed to walking into rooms and being given space. He found the witness stand with the efficiency of someone who had sat there before and had found the experience straightforward. He did not look at the defendant. He settled himself into the chair, adjusted his posture once, and then he looked at me. Not deferentially, the way you look at something you have already assessed and decided is manageable. The defendant was at the table across the room. I will not describe what the defendant looked like, because this case is not about the defendant's appearance. I will tell you this. The defendant had been in this proceeding for 11 months. 11 months of motions and continuances, and the specific exhaustion of watching your life remain suspended while a room full of people with professional distance from your situation move at the speed they move. The defendant's attorney, a public defender, competent, under-resourced, carrying more cases than anyone in that office should carry, had placed a manila folder on the table in front of him before the session began. He had not opened it. I noticed this. I noticed it the way you notice a specific kind of calm in someone who is waiting for a moment they know is coming. I called the session to order. The prosecution began its direct examination, and I watched. The officer's account was detailed. It was fluent. It had the quality of something rehearsed, not dishonestly, or at least not obviously so, but rehearsed in the way that all testimony is rehearsed, the careful arrangement of memory into narrative. He described the sequence of events on the night in question with the precision of someone who had told the story enough times that the telling had become the story. There were almost no hesitations. There were almost no moments where he had to search for a word. I want to tell you what I found significant about that precision, because this is something I learned from both sides of the table. When I was a public defender, I watched police testimony regularly. I understood that officers are trained to testify, that this is part of their professional formation, and I understood that the confidence of trained testimony is not, by itself, a sign of dishonesty. But I also understood, after years in that chair, the difference between a witness who is confident because they are telling what they experienced and a witness who is confident because they have already decided what they need the record to contain. This officer's testimony had a specific quality. It was too complete. Memory, honest memory, has gaps. It hedges. It says, I believe, and approximately, and I'm not certain of the exact sequence. His account had none of that texture. Every detail landed with the same weight, the same certainty, the same unvarying confidence. I made a note. I did not indicate that I had made it. The cross-examination began. The defense attorney, I will call him the attorney throughout, stood from his chair with a deliberateness that I recognized. He was not rushing. He had the folder in front of him, still closed. He asked the officer to walk through the sequence again. The officer did, with the same fluency, the same absence of hesitation, the same architecture of certainty. Then the attorney asked a specific question. He asked the officer whether at any point during the encounter on the night in question, any recording had been made, whether any footage, body camera, vehicle camera, security system, bystander device, captured any portion of the events the officer had just described. The officer's answer was immediate. He said there was no recording. He said the body camera had not been activated. He said the vehicle camera had not been positioned to capture the relevant location. He said the security system at the nearest business had been inoperable at that time. He said this with the same certainty with which he had said everything else. He said it looking directly at me, as he had been doing throughout his testimony. He said it as a man who has said things under oath many times before, and has learned that saying them clearly and without hesitation is the same as saying them truthfully. I watched him say this, and I want to tell you something about what I felt in that moment, not as performance, but as the honest account of what it is to sit in that bench and carry what I carry into it. I spent 9 years defending people in this building. I sat across from clients who had been charged on the basis of testimony like this, confident, fluent, unhesitating, and I watched juries accept that confidence as evidence. I learned in those 9 years what it costs to be in that chair when the only thing standing between you and a consequence you do not deserve is whether the room believes you over the person in the uniform. The room almost always believes the uniform. The room has been trained to believe the uniform. There are very good reasons for this, and there are very bad outcomes that follow from it, and both things are true, and I have never been able to talk myself out of seeing both. So when I heard that officer say there was no recording, I heard two things simultaneously. I heard the testimony, and I heard the weight of it as a public defender, the weight of what it means to have that testimony sitting across from your client with no way to get past it. I said nothing. I wrote nothing visible. I waited. The defense attorney said he had something he would like to enter into evidence. He opened the folder. He placed the first document on the table, a records request dated 8 months prior, submitted to the city's Traffic Management Authority, which maintains a network of cameras positioned at intersections and public spaces throughout the district. The request had been made quietly, methodically, without announcement. The attorney had spent 8 months pursuing a document that his office did not have the resources to pursue easily. He had pursued it anyway. He presented the second document, the response to that records request, confirming the existence of footage captured by a traffic management camera positioned at the corner of 2 streets, streets the officer had named in his testimony as the location of the encounter. Then the attorney asked the clerk to play the footage. The screen at the front of the courtroom loaded. I have been in this building for 22 years. I have been the attorney at the defense table, the attorney at the prosecution table, and the person behind this bench. I have watched evidence change the shape of a room many times. There is a specific quality to the silence that follows when something that was said with absolute confidence is contradicted, not disputed, not complicated, but simply and flatly contradicted by a document or a recording that cannot be argued with. The footage loaded, and that quality of silence filled the room. I did not look at the officer immediately. I watched the screen. The footage showed the encounter. The time stamp was consistent with the night and time the officer had described. The location was the location he had named. What was captured was not the entirety of the encounter, but enough. It was enough to show clearly and without interpretive difficulty a portion of the event that directly contradicted a specific and material element of what the officer had said under oath 5 minutes earlier. I looked at the officer. He was looking at the screen. He had the particular expression of a man who has just realized that the geometry of the room has changed in a way he had not prepared for. Not guilt, or not only guilt, something more complicated. The expression of someone recalculating what they believed was a settled situation. I asked him if he would like to revise his testimony. He said nothing for a moment that was long enough to be counted. Then his attorney, the prosecution's attorney, moved to stand, and I asked him to sit down, not unkindly, but clearly. What happened next is what the title describes. I did not shout. I did not pound the gavel. Those are not the tools of a judge who has been in this room for 9 years and who understands the full weight of what the room requires. What I did was this. I stopped the proceeding completely. I asked for silence, and I got it. And then I spoke to the record, not to the officer, not to the attorneys, to the record, because the record is what lasts. The room, the posture, the certainty of a man who believed his uniform was sufficient, those things are temporary. What is permanent is what is put into evidence, what is stated into the transcript, what is entered and cannot be removed. I said for the record that this court had just witnessed a material falsehood stated under oath in direct contradiction of documentary evidence entered and displayed before all parties. I said that the court was noting this in real time. I said that the proceeding would be suspended and that the relevant parties would have an opportunity to consider what had just occurred and what the consequences of it were going to be. I said it without anger in my voice. I want to be precise about what I mean when I say that. There was anger in me. I will not pretend otherwise, and I would not pretend otherwise in this room. The anger was specific. It was the anger of someone who spent 9 years watching clients sit in that chair with everything at stake while testimony like this. Testimony delivered with that specific confidence, that specific certainty, that specific trust in the room's deference went unchallenged because there was no folder, no records request, no 8 months of methodical pursuit. This time there was a folder. This time there was a camera the officer had not accounted for. The anger I felt was for every time there had not been. But I did not put the anger into my voice. I put it into the record. Precisely, permanently. The record is the tool. The record is what the room owes the people who stand in it. He had been certain that his title was sufficient. The badge was real. The oath was real. The recording was real. Only the story he told me under that oath turned out not to be. I want to sit with that for a moment because I think it is the most important thing about this case, and I do not want to move past it quickly. The officer was not, in the common understanding of the word, a reckless man. He had a record of service. He had been in that witness stand before and had acquitted himself well. He had told a version of events that he may have believed at some level was close enough to truth that the distinction would not matter, because the distinction had not mattered before. The courtroom had never produced a folder. The records request had never been filed. The camera had never been found. What this case required was not heroism. It was an attorney who did not have enough time and did not have enough resources and spent 8 months filing a single records request anyway. That is what changed the outcome. Not a dramatic revelation in the room, the preparation that happened before the room ever convened. The defense attorney sat with a closed folder for an entire direct examination, waiting for the moment to open it. That patience, that precision. I have been in that chair. I know what it costs to do the work when the resources are not there to support it. I know what it feels like to sit across from a witness with authority and confidence and no folder. This case had a folder. What I felt when that folder was opened was not only the satisfaction of seeing a specific lie contradicted. It was something older than that, something from 9 years in the other chair. The proceeding that followed the suspension addressed itself to the record's requirements. The officer's testimony was the subject of further inquiry. The case against the defendant was evaluated in the light of what the footage showed. I will not tell you the precise outcome of every element, not because I am protecting anyone, but because what I want you to understand about this case is not the sentence. It is the moment. The moment when something conducted in the certainty of darkness was made visible by the ordinary, unglamorous persistence of an attorney who filed a records request and waited. That is what courts are for, not the spectacle of it, not the moment I was described as having lost it, which is a particular kind of description that attaches itself to judges when they say clearly what the room needs to hear, when they speak to the record with the precision the record requires. That description has a gendered dimension, I notice, without surprise. What I did was not lose anything. What I did was name what had happened in this room, on this record, in language precise enough to survive me. The record now holds what it holds. The officer's certainty did not survive the folder. What the camera captured entered the permanent account. The defendant's case continued with a record that reflected what had actually occurred that night, not the version presented by a man who had decided, perhaps long ago, that his uniform was a sufficient substitute for the truth. I want to make you a promise before I leave this case. Not a promise about what courts can deliver. I have been in this building too long to make promises about what courts can deliver. But a promise about what this channel is. Every case I bring to this room, this chair, this recording, I bring from all 3 seats I have occupied in that building. The defense table, where I sat across from clients who had everything to lose and a system that was not designed for them. The prosecution table, where I learned to see a case from the other direction and could never entirely stop seeing it from the first. And the bench, where both of those views converge into the specific responsibility of deciding what the record requires. This case required the record to hold something that a man in a uniform had decided it would not hold. The record held it anyway. That is the promise I make in this work. Not that courts always get it right, not that the folder always exists, not that the camera is always there, but that when the folder exists and the camera is found and the records request is filed and the attorney sits down and waits, the record will tell the truth. My job is to make sure it does. I am asking you to make a promise alongside mine. In the comments below, I want to hear from you, not about your opinion of what happened in that room, but about what you have seen. Have you ever watched someone with a credential, a title, a position of institutional authority say something that you knew was not true, and watched the room accept it because of who they were? Write it, not for me, for the record, because every account of a moment when the credential was accepted over the truth is part of the larger account this channel is trying to build. I will read every one. If what you heard today is the kind of account you have been looking for, someone who was in that room, who has been in every chair in that building, who is not going to soften what the record showed, then I would be glad to have you here. Subscribe, hit the bell. What I bring to this channel is the same thing I brought to that bench, the truth as I saw it, from every angle I have occupied, without the protection of distance. The folder was opened, the footage played. The record now holds what it holds. That officer walked into that room believing his title was sufficient. The courtroom showed him, and everyone present, and now you, that it was not. That is what I was there to do.